So then let me officially welcome you all to the 2021 Margaret Brent Lecture and Award Ceremony with Sarah Deer. Thank you, colleagues, students, guests, and friends for joining us tonight at this late hour. This event, as many of you know, is brought to you by the Women, Gender, and Sexuality Studies program and also supported by Lecture and Fine Arts Committee. My name is Betül Başaran, as you see on the screen. I am the coordinator of the Women, Gender, and Sexuality Studies program and professor of religious studies at the Department of Philosophy and Religious Studies. So to begin with, I would like to say thank you first to Sarah Deer for joining us tonight, but also my amazing colleagues on the steering committee, Emek Köse, Aurelia Gonzalez Hurtado, Jesse McDowell, and Seher Şavkat. Thank you all for your amazing work that made this possible tonight. So the order of the program tonight, very briefly, will be as follows. I'm going to say just a few words at the beginning as opening remarks and a little bit about the history of the Margaret Brent Lecture. And then we have a recorded message we're going to play from President Dr. Jordan, who couldn't be here tonight. And then we'll go to the lecture and to the Q&A after the lecture. And we wanted to remind you that if at any point any of you need assistance, please contact the Wellness Center as a resource, and keep that in mind. And you can also use the chat function to reach any of the either myself or any of the steering committee members. Having said that, let me say a few words about the history of Margaret Brent for those of you who may not be familiar with the series at the college. The Margaret Brent Lecture Series was established in 1981 at St. Mary's College to honor distinguished public service among women. And on the occasion of the lecture, the speaker is inducted into the Order of Margaret Brent officially and presented with a college medallion. So normally we do this on stage, but since Dr. Jordan couldn't be here tonight, she recorded a message that will do that for us. As many of you here know, and as Dr. Deer knows very well, in 1648, Margaret Brent appeared before the Maryland General Assembly and requested 2 votes, right? One as a landowner and another as attorney for Lord Baltimore. Now, you probably also know that her request was denied because under English law, women simply couldn't vote, nor could any man who didn't own property. But by contrast, and this is important to note tonight, in many tribal nations, Native women had the right to vote and hold political office prior to the arrival of Europeans. So even though Margaret Brent was no suffragette nor feminist by today's standards, with this lecture series and award, we honor her legacy as a reflection of the democratic values we hold today and our commitment to justice. I'd like to here very briefly mention the latest recipients of the award before Sarah Deer were Angela Davis in 2015, and most recently in 2017, Linda Sarsour, who was one of the organizers of the Women's March in Washington, D.C., who became the first Muslim Arab American woman to deliver the Margaret Brent Lecture. And tonight, friends, in your presence, we're marking another first and making history by recognizing and honoring Dr. Sarah Deer tonight. And I'm honored to welcome you to this event.
Thank you.
So before we play Dr. Jordan's message, I would like to first invite Professor Aurelia Gonzalez Hurtado, who is an assistant professor of Spanish and Latin American Studies here at St. Mary's at the International Languages and Cultures Department. As I mentioned her name earlier, she's a member of the steering committee of the WICSEX program. And I have to express my deepest gratitude to her for bringing the work of Sarah Deer to the committee's attention, and also for making it possible for us to include the following land acknowledgement to our program tonight. So thank you, Aurelia, and with that, I'll turn it over to you.
Gracias, Betül. Thank you, Betül. Good evening to everyone. Buenas noches. Good evening, Professor Dear. Y buenas noches a todos, todas, todes. Before to continue with Professor Dear lecture, we would like to begin by acknowledging that the land on which we are learning, working, and gathering today is the ancestral home of the Yacumaco and Piscataway peoples. We also acknowledge that St. Mary's City was partly built and sustained by enslaved people of African descent. Through this acknowledgement, we recognize these communities and all those who have been displaced and enslaved through colonization. At the Women, Gender, and Sexuality Studies program, we work hard to create a dialogue to honor those that have been currently, historically, and systematically disenfranchised because of race, ethnicity, religion, class, gender, and ability. In this sense, Native Americans' histories, stories, and voices have been long ignored by the mainstream culture, society, and politics of what we call today the United States of America. And moreover, Native Americans, particularly women, trans, non-binary folks, face overwhelming levels of violence. This violence is an ongoing crisis rooted in colonial history. And that is why it is important to recognize today's Sarah Dear's work. Professor Dear is an activist, a scholar, and author who had been devoted her life to advocating for the rights of Native women. So, and now Dr. Jordan, via video recording, will introduce Professor Dear.
Thank you, Aurelia. I will share my screen. Here we go.
Welcome to the Margaret Brent Lecture Series. While I'm unable to be with you live this evening, it was important for me to leave this recorded message to welcome Sarah Dear, legal scholar, university professor, and activist for Indigenous women. Established in 1981 to honor distinguished public service among women, the Margaret Brent Lecture Series has been host to some exceptional leaders in various fields since its inception. And tonight, Sarah Dear is no exception. Distinguished public service is most certainly what Margaret Brent provided to the young colony at St. Mary's City in 1648. Portrayed as an early feminist, Brent was well educated in England, versed in English law, and though not a lawyer, she was experienced as an attorney in the courtroom. Sarah Dear is a citizen of the Muskogee Nation of Oklahoma. She is a lawyer by training and an advocate in practice who has made it her life's goal to end violence against women. Her scholarship focuses on the intersection of federal Indian law and victims' rights, using indigenous feminist principles as a framework. Along her path, Sarah has co-authored 4 textbooks, been published in a wide variety of law journals, authored a book that culminates over 25 years of her experiences working with survivors, and won numerous awards for her work. Sarah, upon being the speaker for this year's lecture series, it is my distinct pleasure to induct you into the Order of Margaret Brent and present you with a St. Mary's College of Maryland imprimatur in the form of this medallion, which we will be sending to you since we cannot give it to you in person. Please accept this award in recognition of your distinction and excellence in your service and work ending violence and helping women survive and thrive. And to all of you, I'm sure you will enjoy the evening. Thank you.
So with that, without further ado, please help me welcome Sarah Dear.
Thank you. Can you all hear me okay?
Yes.
And Can you see a slideshow here?
Mhm.
Okay, so I think we're ready to go. Thank you so much. I'm just overwhelmed by the invitation and the honor, I'm a little speechless. You know, it is a humbling experience when you get rewarded for working on really tough issues, and so I kind of consider this a medal for all of the women that I've worked with over the years. I'm really excited to be here with you tonight. I'm going to talk to you about the intersection of tribal governments and crime victims of all different categories. And so some of the material will be a little bit difficult. I do not have any graphic images or descriptions of sexual violence in the lecture. Nonetheless, I know that many of us who are survivors can really struggle at a moment's notice. You know, you may have a few good years and then your trauma re-emerges in a new way. And so if that is happening for you, you know, do what you need to do to take care of yourself. There are hotlines, chat lines, and local resources that work with people who suffer from trauma every day. So please do keep that in mind. I want to first say a big Mado, which is Muskogee, for thank you for this incredible honor. Now, I know there's no correct picture of Margaret Brent that we know of, or from my understanding, but I've read about her life and her work, and I often teach first and second year law students on feminist jurisprudence. And so we always, you know, kind of start with this story, and that makes it even the more special to me and to my students to receive an honor in her name. But what's really fascinating to me is that a lot of the early English settlements were, of course, populated by Native people. And while I don't know of any writings that talk about if Margaret Brent interacted with indigenous people, it's just not in the records. But other women in upstate New York in the mid to late 19th century, Elizabeth Cady Stanton, Matilda Gage, Susan B. Anthony. I'm sorry, I'm trying to think too many people at once. And they actually were really interested in what's called the Iroquois culture, more appropriately Haudenosaunee culture. And in that culture, only women could own land. So the whole paradigm was different. Women were in charge of the land among the Haudenosaunee, and still are today. And men have other kinds of political rights, but it's an interesting thing. And so a lot of the suffragists that came of age in the late 19th century borrowed some of the sort of styles that Haudenosaunee women did politics, and said, look, we can do everything men can do. And there's several books written about this kind of relationship between early white feminists and the Native populations they encountered in their work. So this is just a thrill and an honor. And I wanted to add one more thing I forgot to mention, which is that I will be able to answer your questions because I will have the chat open unless I mess that up. You know what? I think we might need to wait to the end for the questions, just because the way I've configured everything, I don't have access to the chat bar. Is that okay? Okay.
Yes, absolutely. That's okay.
Thank you. If you do have questions, I want you to just post them in the chat, and I will try to get to as many as I can at the end. I hope to leave plenty of time for questions, but we'll get started. And the story I tell, and the reason I'm here tonight is to tell this story, is this journey of justice that Native people have been on for over 500 years. And I'm particularly interested in how colonialism fosters sexual abuse and how patriarchy activates abuse and encourages abuse. And so to the extent that I want to sort of decolonize the way that we talk about rape, I want to tell you the history of how sexual assault became institutionalized in this country. And that's led to some pretty high crime rates. And then I'm going to tell you more of the victory story, and that is the story of how Native women and Two-Spirit people have come together over the last 20 to 30 years to make major changes in public policy to support survivors of crime in Indian country. So that's sort of the journey of my career thus far. I started out learning about tribal cultures, understanding my own tribe's cultures, and then started to become an activist to address some of the problems that I have been learning about for all these years. So we'll start just by giving you some statistics. Statistics are very dehumanizing, and they are not necessarily helpful for all causes. But what I found is that if you want to get a law changed, whether you're at the tribal level or state or national level, is you need to present a problem that should be legislated, right? So you have to identify an issue that needs a law in order to address it. And one of the ways activists do that is through statistics, to present to a lawmaker, we have a crisis, here's the proof, let's get going, let's do something about it. And so the one that we're using right now, the most recent one that we have, is the Department of Justice report. And it was issued in 2016, and there's not been an update yet, but I know one is in the works. And this report was really the first of its kind to discuss things like interracial crime, and Two-Spirit issues unfortunately did not make it into this one. But these are, what I'm going to show you are some graphs from the Department of Justice. And it's important to remember that this is a federally funded, taxpayer funded research project. So it's not coming from a real biased place, like like an Indian controlled research project that may have some end in sight, but this is just the government's minimum that they have acknowledged in this country. So in the report, you'll find this chart, and as you can see, among American Indian and Alaska Native women, over 84% of Native women will be victims of some form of violence in her lifetime. And specifically, we're talking about a lot of sexual violence. This report cites 56.1% of Native women will experience a form of sexual violence. That's more than 1 in 2. And these numbers look shocking. They do rival other parts of the world in terms of safety and accountability. There's a problem, and the problem's been a long time coming. It didn't just crop up a few years ago. It didn't become a problem, when when these reports came out. It's been a problem for centuries. And so I want to figure out how we deal with this. And in order to deal with a problem, you have to find the roots. You have to go deep and figure out how the problem came to be. And I think that's an important story that doesn't just apply to indigenous issues, but to many, many oppressed peoples who live at different intersections. Is, I have the right to live. I should have the right to live free of violence. The next slide here, and I promise this is the last, I think it's the last statistical slide, is this rate of interracial and intra-racial violence. Now hear me out, because this gets, if you haven't looked at these kinds of numbers before, it can be confusing. Most of the time in America, I think this is across the board for all studies, violent interpersonal crime tends to happen within a racial category. So for example, if you're a white victim, statistically, your perpetrator is white, is more likely to be white, okay? And the same for other racially coded people, is that typically when you have a violent crime, it happens between people who are of the same race. Now, what Native people struggle with is interracial violence. That means violence committed against Native women and men by someone who is not a Native person. So it's a white person, it's a Black person. It's not a Native person that commits the crime. So this first set of bars show you how many female victims and male victims have experienced violence committed by somebody who is not a Native American. And you can see that almost all of the respondents to the study said they had had at least one perpetrator who was non-Native. And then you see that Native people, certainly we do hurt each other. We're not, we are not a perfect people, and we do hurt each other. And so the intra-racial perpetrators are represented below in the bottom 2 bars. So it's not that Native people don't commit crimes against another, it's just that we're much more likely to experience that violence at the hands of someone who is not one of our, who is not also Native. And I'll come back to this important issue a little bit later when we talk about jurisdiction. So the other thing that I've been really interested in doing is exploring the Two-Spirit or LGBTQ plus Native population. A lot of my friends are Native Two-Spirit people. And if you haven't heard the term before, know this, it is not universally embraced. But many Native cultures and spiritual lives of Native people include special and protected rights for people who may not have fit into the gender binary. So there are sometimes 3rd and 4th genders in Native culture. There may be people who went back and forth and were men at some points in their life and women at other points of their life. So it's not, I think that a lot of Native people felt a little left out of the mainstream gay rights movement because they're coming from a different world, a different worldview. And so it was sometime in the late 80s or early 90s that there was a big conference, and they wanted a way to communicate with each other about their identities and their lives. And so Two-Spirit sounded like a possibility because in a lot of ways, some tribal cultures see somebody as having both a male spirit and female spirit. But not everybody really jives with that. Not everybody really feels that that is it's an English word, first of all, and it doesn't really capture how they want to talk about themselves. But when I talk about Two-Spirit people, I see it as an umbrella term that includes basically everyone that would be under an umbrella called queer. So it's not limited to people who are lesbian and gay. It could be somebody who is a 3rd gender or the like. Now, unfortunately, the federal government doesn't do a very good job of helping us study this particular population. And I've only been able to find a few smaller studies or local studies that look at this problem. And this is something that I hope to bring to Congress soon, is to make sure the next time they fund this study, that they ask the participants how they identify in this way, so we can zone in on the problem and try to find solutions. But what I did find is that Two-Spirit or LGBTQ plus Native people report very high rates of violence. And these are smaller studies with smaller sample sizes from localized neighborhoods, but we can see that there is an overwhelming crisis in the lives of our Two-Spirit relatives. So how did we get here? How did we go? Why? The first thing journalists always ask me is why? Why are Native women so commonly assaulted? And it's always a little frustrating with journalists, you know, because I know you're on a time frame and it's like, how long do you have to let you know what the story is? I want to make it very clear that there are over 570 federally recognized Indian tribes in the United States. There are also a number of state recognized tribes throughout the United States, and we're all different, right? So you can't take the principles or the ideas or the ceremonies from one tribe and sort of transplant them in another place. So I have disclaimers. I have sort of a standing disclaimer for these kinds of talks. And that is that what may work here might be a disaster here. And that anybody working on policy reform needs to be very respectful of the different issues that tribes face. You know, there's different priorities and there's different concerns. So please do not take anything I say to be a sort of the Native view on things. I'm presenting my academic research, but it's important to know that each tribe deserves its own distinct treatment. But what we do know, what I've come to believe, is that many of our tribal nations we're very victim-centered and restitution-based when it comes to violent crime. What I mean by that is, it wasn't, if an assault happened, it wasn't necessarily treated by a carceral punitive response like we see in the Anglo-American system. It would be about the victim and his or her desire for accountability. And that accountability might be in the form of payment, not necessarily money, but some sort of material goods that would be provided to the victim. And the victim had a loud voice in these kinds of issues. There were some, zero tolerance principles in some of our tribal nations. Like, there's not a 3 strikes, you're out. If you mistreat a child, you're out, and you can leave the tribe and you're no longer welcome there. And then the interesting thing about a matrilineal society, not all tribal nations are matrilineal, but a lot of them are. And if you know about Jewish identity, you know kind of what this is about, that the child is the identity of the child comes through the maternal line, right? And so in that kind of culture, it's like women are centered in the family more and have more authority. It's not really matriarchy in a dictionary sense, but it's more egalitarian, I guess is a better way to see it. So we had these systems that worked well, and I want to interrogate them just a little bit to give you some more specifics. So when I was in law school, for the first time, I didn't grow up knowing much about my tribal identity because I was in Kansas growing up, and my tribe's in Oklahoma, and we didn't have a lot of contact. So I became really interested when I went to law school in understanding maybe what a Creek response to violence against women looked like. And I should also explain that Muskogee and Creek refer to the same group of people who were known for as Creek Indians by the English. And then our word for ourselves is Muskogee. So you'll hear them used interchangeably. I came across the journal and writings and papers of a man named William Bartram, a naturalist. He was kind of a Renaissance man. He did a little science, a little invention. He loved botany. And he decided, I think he was Quaker too, and he decided to travel down to what is now the southeastern part of the United States and spend several years there categorizing plant and animal life. He was an artist, so he would draw plants and talk about them. So during this time period, while he's doing this, he's living in tribal world. He's living in a world with a lot of Creek Indians and a lot of Cherokee Indians. And so he had, of course, interest in their goings on, and he became friends with many people and spent, like I said, he came back and forth, I think, over the course of 10 years. So in a lot of his writings, he notes that there's no gender violence. He doesn't see a disrespect for women, even in speech. And he thought this was remarkable, and wrote back to his friends and kept his journals about, it was really an inspiring and interesting culture to see one where women were not regularly victims of their husbands or partners. So that really intrigued me. And as a young scholar, I thought, well, I'd like to know a little more about this culture. And so I continued to dig into the archives. And the next thing I discovered was the first rape law that my tribe wrote down. Prior to colonization, most of tribal cultures did not necessarily have a writing system. There might be a symbolic system, but it wasn't not really what we call an alphabet of any kind. And so we didn't have a written language in 1824. Our written language came about in the 1840s after removal. So what's interesting is that this law would have been an oral law, right? Because laws were conveyed to the people through speeches and songs and ceremonies. But we got a lot of pressure to assimilate really fast. And we did. We married a lot of Scottish immigrants, set up farms and kept governing ourselves. And in 1824, we were asked by the governor and the Indian agent to write down our laws in English. And they said, if you do that, then you will be treated as a civilized people. And if you don't do that, then you're just another heathen. So you make these, you know, in genocide ethnic situations, you make decisions that may not make sense now, but they did. They wrote down, the ancestors wrote down these laws, and obviously you can see why it captured my attention. Most of the laws in this collection, there's about 55 or 56 laws in this collection, are criminal laws, almost all criminal laws. And they largely look like 19th century state rape laws. Now, at this point, you know, in many conceptions of Anglo-American legal jurisprudence, women were essentially still property of some kind. And certainly we're living in a place where women were not likely to have people believe that they have been assaulted. They have to have 3 witnesses, or, you know, there's all kinds of English history that talks about, you know, the laws of rape and the fact that you couldn't legally rape your spouse. So anyway, there were a lot of laws that we copied word for word, basically from whatever we saw in the state law, but this one's different. This one suggests, because this certainly wasn't happening in state court, but this suggests that there was an understanding of gender. Unfortunately here, of course, it's a gendered law. You know, right now it would only apply to a woman victim or a male perpetrator. But I'm still fascinated by this reference at the end, what she say, it be law. And that's what I've tried to tell the story of, is how do Muskogee women say what the law is when it comes to victimization. So this is what started my journey. And I found this when I was still a student, and I'm still talking about it 25 years later. So, you know, there may be a moment in your undergraduate or graduate education where you kind of do this, oh my gosh, this is what I want to do for the rest of my life. And that's what the story of this law and my experience working with it. And I share it with a lot of people, and it's interesting to talk about all the components of the law. So if you kind of go along with my thinking that we had civilizations on this part of the planet for tens of thousands of years, I don't think civilizations can truly sustain themselves if 80% of the population are victimized. I don't think that's sustainable, right? So I tend to also make an assumption, and I'll just lay it out as such, that there may have been some tribes where women were treated very poorly, right? So that always has to be part of the back of the conversation. So why the journalist call, why do Native women and men suffer such high rates of violence? And you have to base the answer of that into a historical context. And so that's what I hope to do here. I'm going to talk about 2 things. I'm going to be talking about federal policies, and I'm going to be talking about federal law. And I'll start with the policy. And I've only selected a few snapshots. The whole story is obviously, you know, could be an encyclopedia. So I'm providing specific examples that are not necessarily the only policies that did harm. So let's talk about the word sovereignty. Sovereignty is not a word that we use, in my experience anyway, is not a word that we really use a lot unless we're talking about a tribe. But what I mean by sovereignty is that as a nation, as a government has the inherent right to decide what happens, pass laws and be governed by those laws, and create courts and hire police, and that's how you govern yourself. You know, you develop a system, a formal system of resolving disputes and responding to crime. And so we take it for granted in other contexts, right? So we take it for granted that the state of Maryland has sovereignty. At least I do. I was born there. And nobody really ever talks about Maryland's sovereignty, right? I'm in Kansas. I rarely hear anything about the fact that Kansas is a sovereign state. But when it comes to tribal nations, we have to talk about sovereignty, because our ability to protect our own people has been significantly damaged by colonialism. And so you have to talk about this idea of a sovereign tribe when you're trying to figure out how to put the pieces back together and improve the situation on the ground. But as a rape crisis advocate and a survivor myself, I found that sovereignty, as I thought about it, could also be applied to the individual, right? That we are human in whatever spiritual world that means for us. We are human, we are here, we should decide what happens to ourselves and our bodies. And what happens when someone assaults another person is they've violated that individual person's sovereignty. If it's sort of like a metaphor, if you will. But I think it might be more than that, actually, because I think that the safety of Native women is dependent on the sovereignty of tribal nations. So I want to give a little bit of history here, that there was rape upon contact. Columbus Day has been a topic of controversy for many years now. Many states are doing away with it, or renaming it Indigenous Peoples Day. Columbus was not a good fellow, and he had friends that were not very good fellows either. And one of his friends that came on the second voyage actually kept a journal where he bragged about the women he raped, the Native women that he raped. And so he was not ashamed of this. He was not trying to hide it. It became part of his, public record. And so right away we have documented cases of sexual assault happening by European men against Native women almost immediately. The policy that I want to talk about first is the removal policies. Many people have heard of the Trail of Tears, and that's sometimes the only thing they learn in the public schools about Indians. And the Trail of Tears refers to the Cherokee experience of being forced to move to Indian territory against their will and go to this Indian country area, which is now the state of Oklahoma. Okay. But it wasn't just the Cherokees, and it certainly wasn't just about tears. These were our homelands. These were our homelands for thousands and thousands of years. And to be moved summarily was even suggested to be a form of ethnic cleansing. Even the secretary of the Bureau of Indian Affairs in the 1990s said this period can be classified as a form of ethnic cleansing. Many people died along the way. We didn't have doctors. We had children, really young children that just couldn't deal with the exposure and the elements. And of course, the elders, who couldn't make the march, we had to just bury them by the side of the road and go on. And so by the time you have all of these tribal groups in Indian territory, we've been horribly traumatized by what has happened. And the other thing that we know today that I don't think we knew then is that when you do have areas of ethnic cleansing and genocide, there's usually almost always guaranteed to be sexual assault happening along with whatever political issues are on foot. And so I have found stories, usually from missionaries. Many sympathetic missionaries made the walk with the tribal people, of rape happening during the Trail of Tears and the Trails of Tears, that the military was in charge of this. So they called the shots, and who do you report to? Nobody was ever held accountable for these things, because who do you report the crime to if you are a person outside a government with no government protection? And so we have to think about that and how that has affected the contemporary lives of Native people, the memories that get sort of passed down from generation to generation of these really painful periods in American law. Removal happened all over the continent. I think the Trail of Tears is the most well-known, but there were forced movements all over the United States. And still today, even we see people being moved without their consent. But of course, it didn't happen just in the Southwest or Southeast. We also had something called the Long Walk, which was the forced relocation of the Diné or Navajo people. This is a picture that I find really intriguing, but I'm always hesitant to show it. We don't know much about the picture. It was taken in the 1860s, and we know that these are Diné women or Navajo women, and we know that they were being held hostage essentially at this point when this picture was being taken. I don't know what much more than that, but I have to wonder, given what I know about forced removals and ethnic cleansing, that these women and children in the picture may have been going through something more nefarious than just being cold and hungry. Another issue, just the policy issue that people think about when they think about land loss. You talked about stolen land, we've talked about swindled land, treaties that were just outright violated from the moment that the pen was dry. So at the end of the 20th century, you can see here that Indians really only control a fraction of the continent. And the reason this is important in the context of victims and survivors is because a lot of Native spiritual beliefs and ceremonies are tied to and interwoven with some element, like a prayer rock or a sacred river or a mountain or cliff of some sort that has a physical presence that's majestic. And you cannot properly engage in that ceremony or that prayer if you are not in that place. And so, losing all that land, great. We can often agree that that was unfair, but what I want people to do is dig a little bit deeper and think about the long-term impact on victims who were, moved 1,000 miles away from where they had always lived and can no longer perform the ceremonies that they perform. And the level of trauma that can add to the lives of a victim. And the last policy I will mention is what historians and Indian scholars often call the boarding school era. During the 19th century, there were many parts of the United States where the goal of the Indian problem, that's what it was always called in the press, is the Indian problem, was extermination. And the Indian Wars and the Great Plains were indicative of that there were American officials who said, kill every last one of them. They're in the way, they cause too many problems, and just wipe them out. That became expensive. And frankly, maybe, the reason that Congress changed its attitude is because it became cheaper to brainwash an Indian child than to kill it. And so what this meant is that these children were taken from their families and sent to these residential schools for all of their childhood, far, far away from their families, far away from their language and their spirituality, and denied access to their own heritage and lineage. So this happened again all over the country. The first well-known school was in Pennsylvania, and that's where these children were sent. You can see here that this was taken by the military, and that's probably because the military was involved in rounding up some children. And this happened in Arizona, and I believe that these are Apache children. This is the same group of children just a few months later. So I'll go back again and see the before and after pictures. So what's going on here is that they're essentially attending sort of military academies, for lack of a better word, being banned from speaking their language, being denied access to prayer medicine, and basically brainwashed. I mean, I don't know, we can talk about assimilation. It seems to me to be sanitized a bit. I think brainwashing is probably a better way to describe what happened here. And this affected many, many tribes. In some cases, almost 30 to 40% of the children of that community were rounded up and taken to a boarding school. So they lost their identity, they lost their heritage, they lost their identity, and they were not allowed to return home, even if somebody died. And so it was an incredibly disruptive era of a cruel inhumanity to the lives of these Native children. And again, can we dig deeper? Because if we do, we will find out that some of these boarding schools were very attractive to pedophiles and sex offenders, right? And so we know that these children, and this era extended into the 1960s, and we have survivors from these boarding schools in the 40s, 50s, and 60s who are still living, who have reported massive amounts of sexual abuse against Native people, in the children in particular. So this disrupted our cultures and our ways of life in immeasurable ways. And the motto of this school, this is the Carlisle Indian School, the motto of the head of the school was "Kill the Indian and save the man." And so it really was a replication of extermination, just in a different form. Skip some things here. Okay, now I'm going to be talking, I'm watching the time here. I'm watching the time, and these are the 3 laws that I want to talk about. 2 of them are basically federal statutes, and the 3rd is a federal Supreme Court case. So I'll try to get through these, because here's where we have the policies that create the environment for sexual abuse to be cultivated. And then we have actually legal barriers to letting tribes respond to crime, so that they can better protect their own people. So I'm going to start with the Major Crimes Act. These are 2 Lakota chiefs from the Dakota territories in the 1880s. And they were both chiefs of a particular band of Lakota Indians. On the left is Crow Dog and his horse and his gun, and on the right is Spotted Tail. And these men had a longstanding rivalry of sorts that different historians find different examples or reasons for this feud. Crow Dog was less friendly to whites than Spotted Tail was. And one day, Crow Dog shot and killed Spotted Tail. It culminated in a homicide. So Crow Dog here on the left was adjudicated by the Lakota people and their system of governance. He was found responsible for the homicide, and he was his punishment, or the sanctions imposed upon him, were to care for Spotted Tail's descendants, his family, and any children and grandchildren that were to come along. So Crow Dog was not, punished by a carceral system, but he was indebted to his victims' relatives. And Spotted Tail had a very large family. So that was resolved as far as the Lakota people were concerned. And that was the solution and the problem, that they chose to address it in that way. Well, the white folks that lived in this area, and the Indian agents in particular, were pretty upset about the outcome, because they saw Crow Dog as a real problem Indian, and they thought he got away with murder from their standpoint. So they said, we're going to prosecute Crow Dog. So they sent federal agents and picked him up and took him into federal custody, and he was brought before federal court. And he had a really good attorney, and they made a great argument in front of the Supreme Court. And that is that Crow Dog is not a United States citizen. Crow Dog is the citizen of the Lakota people, and his people and their government have decided the outcome of this case. Why would a foreign government come in and have power here? Right? This is treaty land. This is our land. It's not your land. And it's our people. It's not your people. So why would the federal government, where would the federal government get this authority? Where would it come from? And the Supreme Court agreed, and they freed Crow Dog, and they said, we don't, they weren't very Indian friendly Supreme Court. I mean, we're called savages throughout the opinion. But nonetheless, the court decided that Crow Dog was correct, and that essentially the federal government coming in to prosecute him was the equivalent of France coming over and prosecuting something in Kansas. Like, it just didn't work. So Crow Dog walked. He was, of course, still beholden to his lifetime commitment to the Spotted Tail's family, but he was not able to be charged federally, and so escaped the death penalty, which is what they had ordered. Okay, so this upsets, now people are even more worried, right? Because not only has Crow Dog, this bad Indian, killed this good Indian, but then he got away with it federally. And we can't have that happen again. What happens the next time Crow Dog kills somebody? We have to have this power the court says we don't have. And so Congress passed a law, and it's called the Major Crimes Act. And it's still good law today, believe it or not, 1885. So they went to Congress and they said, hey, Congress, the Supreme Court says that we can't prosecute people on Indian reservations. Can you fix that for us? And that's what they did. They just unilaterally created a federal law that was not signed on to by any tribe. It was not the request of any tribe, but essentially said, going forward, if it's anything like the Crow Dog situation, we will have authority as the federal government. Okay? It violated many treaties. This law did. It's still good law today. So many times on Indian reservations, especially in the lower 48, instead of having a state respond to a typical domestic violence case, it's typically the feds, the federal government, the FBI that investigates and prosecutes those cases. And so it's a very different setup than what you see, off reservation land. And so today there are many areas of the country which are covered by the Major Crimes Act, meaning that if a crime is committed on an Indian reservation, the federal government, by its own decree, is going to be the arbiter of justice. Okay, so it's still relevant, still alive today. The problem with that is they don't do it. They do not prosecute these cases. The Denver Post about 10 or 12 years ago did an investigative series about the lack of action on these kinds of crimes. And they found in a couple of different years that United States attorneys actually turned down over 70% of the sexual abuse cases that they were presented with. And those are the ones that were reported, right? So we're talking about a minor category of people, and yet the US attorneys decline over 70% of sex abuse cases. So they have the power, and they haven't historically used it to any good to help people, because the Major Crimes Act was about getting revenge on Crow Dog. It wasn't about protecting Native women, and so this still exists in this weird way that we have to navigate. The other law that I want to mention is the Indian Civil Rights Act, which is from 1968, and this was another act of Congress. And the name of it sounds great. We had the Civil Rights era, the Civil Rights Act, and the Indian Civil Rights Act. It sounds like it would be a progressive piece of legislation that would provide more access to political capital for Native people. But in fact, it really didn't do that. It did a lot of things, and I won't go into most of them. But one of the things I wanted to talk about was this carceral sentence limitation. So the law does, like I said, several things, but it also says that the maximum penalty that a tribe can impose for any crime is 1 year. So that'd be 1 year for vandalism and 1 year for murder, and there's no distinction. Tribal courts just are barred from giving anyone a carceral sentence that some victims would like to see. And we may circle back on this issue during our discussion in your questions about the use of jails and prisons to resolve crime in Indian country. Finally, I have to talk to you about another Supreme Court case called Oliphant versus Sukwamish. And this was a case from 1978, so it's not that long ago. The story of this case is about a couple of white men that lived on the Sukwamish reservation, which is in Washington state. And these white guys got a little drunk and disorderly on the reservation one night. I think they lived on the reservation themselves. And they made a scene, and there was some, assault on a police officer, and until they got everybody kind of calmed down. But they'd broken several laws by the time the evening came. And so they were prosecuted by a Sukwamish Indian tribe. And they said, their argument was, we should not be held accountable in Sukwamish courts because we're not Sukwamish, we're white. Okay, that was their argument. Now think about using that in another context, right? I'm in Kansas right now. Let's say I drive down to Oklahoma tonight and I rob a liquor store and I get caught and I get arrested. And the next day I say, well, you can't prosecute me in Oklahoma because I'm Kansan. I'm from Kansas. And so that's why you can't prosecute me. That's essentially the argument they were making, because this is about a political identity, right? This is about a citizenship question. But they won. And unfortunately, with the US Supreme Court, when they decide a decision on one Indian law case, it applies to all Indians, regardless of their circumstances. And so no tribe since the 1970s has been able to prosecute a non-Indian for harming a member of their community. And that's why I wanted to share those intra and interracial crime data with you, because it doesn't, I think that part of the reason there is such a high rate of interracial violence in the lives of Native people has something to do with this, that there is a sort of knowledge out there, or an expectation that white people can get away with doing things on tribal lands. Now, because of Oliphant, there are mechanisms by which the state and or the federal government can prosecute those crimes, but the tribe cannot. They have no authority over a non-Indian. So this has got to be fixed. Somebody asked me what my mission in life was. I said Oliphant. So that's what we've been working on. And so now I just have a few more minutes, and I want to share with you that we're seeing some major changes that are going to make a huge difference in the long run for Native people, particularly victims of domestic violence and sexual assault. So this is the activist portion of the program. I'm now done with my law professor portion, and I'm now putting on my activist hat. The first thing that we got to work on was the Tribal Law and Order Act, which was passed by Congress and signed by President Obama in July of 2010. So let me just put the caveat up front. It does say tribal law and order. And we know that for many people of color, the term law and order is not necessarily one that connotes a positive response, right? That in fact, Biden was heavily critiqued and still is today for the way in which he approached law and order in a very punitive way. And there's pushback on that kind of language. So know that I'm aware of that first. The Tribal Law and Order Act was designed to do a couple of things. One of the things it did is it put more accountability measures in for the federal government. So, you know, I said earlier that the federal government was declining all of these cases and leaving victims with no justice. Well, now they have to tell us what they're doing. And before they said they couldn't find the numbers, or they didn't have a computer software to do it. Denver Post figured it out, they figured it out, and we were able to figure out this declination rate. So in this law, we put that every year, the United States attorneys have to give a report on their activities and their exercise of authority in Indian country. So there's that. So we can still get more information, but that was a good start. And then the other thing it did is it changed that sentencing limitation to 3 years. And again, there's probably a good conversation to have here about why 3 years, why not 10, and why are we even talking about a carceral system in the first place. But they did make some changes. And so that really convinced me that we could actually do more. Because when I was a young bureaucrat working in Washington, D.C., right out of law school, I told everyone from day one, why don't we overturn Oliphant? And they all just kind of patted me on the head and were like, oh, that's sweet, never gonna happen. And so, but this made me believe that it was possible, that we could get enough national attention to the issue to actually be able to change federal law. And then Obama signed the Violence Against Women Act in March of 2013. So it's just been, what is this now? Is it really 8 years? I can't do the math in my head. Oh my gosh, I can't believe it's been that long. But the Violence Against Women Act was originally passed back in 1994. It was the first real federal effort to address gender-based violence. We authorize it every few years. It's supposed to be every 5 years, but sometimes it's every 6 or 7. And we were able to get a portion of this Violence Against Women Act to fix Oliphant. Not very much, but we did convince Congress that we as tribal nations should be able to prosecute anyone in our community that commits an act of domestic violence, no matter if they're Indian or not. And believe me, that was a fight. It almost melted down, and the whole VAWA almost melted down on this issue, because There's some inherent fear among lawmakers, especially Republican lawmakers, of tribal authority. They're often very suspicious of it. They often have never been to a tribe, and they represent a state with no tribes in it. And they were not happy with this idea. Like, wait a second, I could go to an Indian tribe and get in their court? Oh, that doesn't sound fair to me. And pushed back on this quite heavily. But thanks to the White House and all of the activists and the grassroots folks across the country, we were able to get that provision in. So today, as of March of 2021, we are able to prosecute non-Indians who commit acts of domestic violence. That doesn't cover sexual violence, that doesn't cover child abuse, it doesn't cover homicide, but we had to take what we could and say we can do this. And once we establish that we have the appropriate mechanisms to achieve justice, then they will overturn Oliphant altogether and give the custody and the jurisdiction of criminal matters back to the hands of tribes. So we're going back and asking for sexual assault, asking for homicide, child abuse, child sexual abuse, and also assault on a police officer, because right now, a tribal police officer doesn't have tribal protection from assault by non-Indians. So we hope that will bring some more bipartisan folks to the table. So that's what we're working on now. We've also worked on several Supreme Court cases that have an impact on victims. And the first that we worked on was a Dollar General case. You all know you all know Dollar General. There's like $1 trillion general retail establishments, and actually lots in Indian country. Sometimes Dollar General is the really only retail store on an Indian reservation. And this case involved a child, a male child of about 13 years of age. And he got a special, he was part of a special job program at the Mississippi Band of Choctaw, which is a fairly wealthy tribe comparatively, but not, the richest tribe in the country, but does okay, provides a lot of employment opportunities for their citizens and runs many businesses. And Dollar General joined with the tribe to say, hey, let's do something to keep the kids off the streets this summer. Let's let them try and kind of like try different kinds of jobs. Like this week you're going to work in a retail place, next week you're going to work in a dairy farm. And so this child was put into this program under that plan, and he was molested by the manager of the Dollar General store, and he was a white man. The perpetrator was a white man. So of course the tribe can't prosecute him. He was found out, the child reported right away, and the manager was fired and banished from the reservation, but there's no criminal justice here. And so the federal government declined to prosecute this case, and I don't know the reasons why they declined it, but I think it was because there was no actual penetration. It was fondling, right? So the parents of this child decided to file a lawsuit in civil court, like a personal injury lawsuit. Like if you get in a motorcycle wreck, you hire a lawyer and they sue the person who caused the wreck and they compensate you. Same idea here. We're going to file a civil lawsuit in tribal court against Dollar General, saying that they should have known, or should have reason to have known, that they'd hired someone with a history of sexual abuse, and then get money from Dollar General as the goal. Not that money makes up for it, but it would pay for this child's education, counseling bills, medical bills, and that kind of thing. So that's what they decided to do as the family. And of course, the first thing Dollar General says, we can't be held accountable in tribal court. We're not tribal. Same thing with Oliphant tribe, right? So they were just determined to not be held accountable in tribal court. And the thing is, they had a pretty good case. They could have won in tribal court because it wasn't clear that the management had any knowledge or pre-existing idea that the person they had hired had a history. And that's what they would have had to show. But they didn't want to go to tribal court at all. And they spent the next 5 to 6 years spending millions and millions of dollars on attorneys' fees to fight this case so that they would not have to be a litigant in tribal court. So we decided to write an amicus brief representing victims of abuse in Indian country and tell the story of how this will impact victims. Because at this level, when you get all the way to the Supreme Court, it becomes almost like a mechanical question. of law. Here's the tribe, here's Dollar General, what do they, how do they interface? And the soul and the hurt that's at the essence of this case is what we wanted to make sure the Supreme Court knew about. And so we filed a brief explaining the potential ramifications for victims should Dollar General win this case. And we had activism outside the Supreme Court the day of the oral argument. I was inside listening to the arguments, and we had an incredible show of activists, grassroots activists from all over the country to make a stand on this issue. And it ended in a 4-4 tie. So we don't have a victor here. The tribe won at the lower level. So what happens when you have a tie at the Supreme Court is whatever the lower court decided is the law. And so then as the child now, I think he's about 30, that case can proceed in tribal court. And then, so we said, well, if this works, you know, we don't know if our brief was the reason for the people's different justices' votes, but we've been filing other briefs in cases, talking on behalf of Native victims of gender-based violence and explaining how the outcome of these particular cases could negatively impact the lives of victims. So we had United States versus Bryant, Gamble, McGirt, and we currently have a pending case that you may want to look at if you're interested in the law, called Cooley versus the United States, which implicates the question of tribal police authority over non-Indians. So we filed a brief there too. So there's ways that we've worked sort of in the streets and in the classrooms and then, you know, in the courtrooms. And that's the exciting thing that I like to share, is that once you get passionate about something, you know, you really find it difficult to let it go. And this became my life's work because of that Creek rape law from 1824 that I found when I was in law school. Thank you so much. I'm looking forward to answering your questions.
Thank you so very much, Sarah, for your time and and sharing your life's a snapshot of your life's work and passion with us tonight. Sure. We have some time to take questions, and the floor is now open for questions. You can, if you want, put them in the chat, but please feel free to ask your questions directly to our speaker.
Well, there's one question posted. Should I start there?
Sure, why not?
Okay. So the question was, what is it now that you can prosecute non-Indians on again? You mentioned that it didn't include some things. Okay, so Oliphant as a whole says no tribal criminal authority over non-Indians, period. That's what Oliphant said. So what we did with this version of the Violence Against Women Act, we showed them all the stats, you know, we showed them the interracial stats. And some of them were like, well, that looks like a problem. And what we were able to do, we said, we want the whole thing fixed. We want all victims of an Indian country, all victims, both Indian and non-Indian in Indian country, to be governed by the same system. It just doesn't seem that complicated to me, but it is. So we were able to convince Congress that non-Indian domestic violence perpetrators were likely to be married to a tribal member, living with a tribal member, having a child with a tribal member, and that those particular non-Indian domestic violence perpetrators would be on notice that they could be held accountable. And they would better be able to understand, you know, how to live within the community, and shouldn't be in a marriage and the tribe can't do anything to help the victim. And they bought it, and they bought it because it was sort of like, okay, well, those guys kind of know what's coming. But if you're just wandering through a reservation and you happen to make, you know, commit a crime, you know, and you don't even know you're on an Indian reservation. So what happens then? There's all this kind of fear mongering that goes on. So we have, tribes can choose this, by the way. This is another great thing about VAWA and Taloa, is they don't burden tribes with new obligations. What they do is open up more opportunities for tribes to do the things that need to be done. Okay, so that's a big change in sort of how federal legislation has worked in the past. So if it is a non-Indian who commits domestic violence, dating violence, or violation of a protection order, those are the 3 kinds of crimes that we can prosecute if committed by non-Indians. Everything else is still off limits. So we want the whole thing overturned. And believe me, there's been like dozens of law review articles over the years saying the same exact thing. We should overturn Oliphant because it doesn't make sense in the modern era. We thought, okay, well, if we get domestic violence in and we show them that we can do this, like, we don't know what it is they're expecting us to do. Maybe they've watched too many Westerns in their childhood or something, but we'll take it and then we'll prove we can do it right. And then we'll overturn Oliphant at that point. And so it's been successful. In fact, the very first case, which didn't happen for a long time, was actually very interesting. It happened at Pasquayaki, which is a tribe near Tucson, Arizona, on the border. And there was a relationship between a Black man and a Yaqui man. It was a same-sex relationship. And the Black man repeatedly beat his boyfriend, who was a Yaqui tribal member. And it was very, very violent. And so it went to Yaqui court and they prosecuted it there under VAWA, even though it was a same-sex couple. And he was acquitted. So, you know, he was found not guilty. And unfortunately, the reason we think that happened after doing some research is because they didn't see the relationship, or the jury, I should say, the jury did not think of this relationship as a valid domestic relationship. So they nullified the law in a way by just saying like 2 men together doesn't fall under domestic violence. I can't prove that's what happened, but that's one of the theories from people who've been more involved in that case. So from the very first point, it's like, we're not going to railroad anybody. We're going to make sure everybody has the same rights within our court system. And so we're hoping that with Biden and the new Violence Against Women Act, we can go back and ask for an Oliphant fix again. You know, and if we can't get the whole thing, we'll take what we can. Well, we need sexual abuse on there. We need a homicide on there. A tribe can't even prosecute a non-Indian who commits an act of homicide in our own communities. So we're going to go and ask for that. We'll see what happens. But I'm feeling very, very hopeful that we are moving in a whole different direction. And this is not just a new era for victims of crime in Indian country, but for all of Indian country. And I think small governments can be very efficient, especially, you know, when they have a group of strong leaders at the table. So I'm currently advising my own tribe on this issue, Muskogee Creek Nation, and have worked with other tribes on remedies that are customized to the experience of the people who are going to be held accountable. It was a very long answer to your question, but I got very excited about it.
We have another question for Michael Dunn. So Michael.
Thank you. Thank you so much for being here. We so appreciate it. And to hear you kind of lay out this entire framework in history is really stunning. And I think the fact that you have dedicated your life to this work and that you maintain hope and perseverance is just really inspiring. Thank you. Just, you know, looking at the legal landscape, it's like, what about equal protection? How can any of this be happening? It's crazy. But one of my roles on campus is as our Title IX coordinator. And so I was really fascinated to hear about sort of how different tribes and groups in Indian country have addressed issues of sexual violence through a very different framework than our kind of prosecutorial model, right, which I don't think is really serving any community in the country very well at all. And of course, that prosecutorial model kind of trickles down to sort of campus sexual violence and Title IX issues as well in many degrees. Right. And I was wondering about these recent Supreme Court cases, especially McGirt from last summer. And I was curious if those victories create any space for tribes to kind of employ more of these sort of non-prosecutorial, more like kind of restorative justice techniques. And if that will create opportunities for places like Maryland and us here at St. Mary's to kind of learn from that and improve our processes.
Yeah, thank you so much for that question. Yes, carceral systems do tend to trickle down, and Native communities have always been under immense pressure from the federal government to assimilate their legal systems. At one point, the BIA, I think it was in the 60s, just created, it was like a Mad Libs. It was like, here's a list of laws, white out the name of the last tribe that used it and write in your own, make a copy, and now you have laws. So they weren't even written by Native people. You know, they were like, if you think you want to be a government, this is what you got to do. So a lot of tribes operate with a very Western law and order framework. What we know is also that there are sometimes two parallel systems in some tribal nations. I think the best example of this is the Navajo Nation, the largest land base of any tribe at the Four Corners. And they have a peacemaking court. And it is no lawyers allowed. It is a place of solace and solitude to resolve a difficult issue. And it can be used for probate issues, it can be used for child custody issues, it can be used for juveniles. If both parties agree to move the case from the Western system into the peacemaking system, then they can do that. But both parties have to agree. Some tribes have always been underground and been doing this the whole time. It's nobody else's business. We handle our own. And so I don't have access to what probably are some really brilliant models out there, because some of that information is just not anyone else's business. But no, to answer your question directly, no, there's nothing specifically within the language of the federal statutes that encourages necessarily a different approach, but it opened the door, right? So you're talking about McGirt. McGirt was this huge decision last July. It was the only great thing that happened for me during COVID, is that our tribe had been arguing for a long time that our treaty had been broken unlawfully. And the Supreme Court agreed and actually upheld treaty rights. It's nearly, I can't tell you, there's only a handful of attorneys that practice treaty law. And it is nearly a, it's almost an impossible job, because the court has said that the government can break treaties. So, but we won a treaty case. And so what that means is that what is considered our Indian country, Indian country is a legal term of art that refers to the status of land. It's not kind of, so it's a term of art that lawyers use. And then we went from about 150,000 acres to 3 million overnight. So we have now the reservation that we were promised in 1866 is back. We always knew it was there, but nobody else agreed until the Supreme Court agreed. So we have to now figure out how to configure a government that used to patrol 150,000 acres and become a sophisticated 3 million acres, which includes most of the city of Tulsa. So this is the perfect opportunity for us to have these conversations. We have been using a Western model. It's always been infused with tribal language and some ceremonial aspects, but it's like a courtroom, but there's a lot of Indian art on the wall, but it's essentially an assimilated court system. So now that we have this opportunity to figure out how we're going to govern this entire new area of land that we haven't had control over, this is the perfect time to have those conversations. Do we really want to just explode our police force? Is that the solution here? Do you want to build a jail? Some of my fellow tribal members would think that would be a good idea, because at least they wouldn't experience the racism that they do in county jails. But there's no reason that we can't rethink this. We have to provide due process to everyone, and that's just a generic phrase of, fairness. Everybody should get due process. But I think that tribal nations at this point in history are in the best position to rethink how victims experience justice and what makes a community safe. So thank you for that question.
I have a question. In your book, you mentioned that the media outlets describe this violence against women or Native women as an epidemic. And you have a strong opinion about the use of this word.
So if you've ever written a book or plan to, there's going to be a point in time at which you look back and think, wow, I really wish I wouldn't have said that. And this passage that you're referring to is one of them that if I ever get to do a second edition, I'm going to reframe a bit. So my problem when I was working on the Hill and trying to get lawmakers to get their heads wrapped around this is that, you know, the headline on the news and the NPR was all about there's this epidemic of violence in Indian country. And as a lawyer, that sounded to me like some kind of biological reference, like a disease. And a disease is not culpable, you know, in that sense. So for me, I was like, it's not an epidemic. It's not something that just came from the biosphere and infected us. This has been a part and parcel of the colonial process. And that's what I meant by that. But I don't use that word. It's a word of social sciences, but I don't really use that word in a legal sense. But I got a little pushback. It was the first time someone read my book and kind of sent me an email. I got something for you to think about. And it was very friendly. It was from a medical anthropologist. And she said, all epidemics are political. And so you got it a little bit backwards here. You know, think about AIDS, think about the flus and the disparate impact. And now that I've experienced living during a plague myself as a human, I might rethink that as a real problematic word. It does describe a political crisis. So just one of those things that you look back and 10 years later and thought, gosh, I really don't like the way I ended up phrasing something. It happens to all of us.
Thank you. Thank you.
We can probably take one more question.
I think Jacob Neely, Dr. Jacob Neely wants to.
Oh, yes, please.
Hi, how are you doing?
Hi.
Hi, I'm Jacob Neely. I'm a visiting assistant professor of Spanish with Argelia in the same department. And currently I'm teaching an indigenous studies course about the history of representation of Mesoamerican peoples in Mexican and North American literature. Mm-hmm. And so this is a big theme that's come up in the course is that like a lot of the borders between Native American lands and the nations have been artificially drawn. And one of the biggest artificial borders is the border between the United States and Mexico, right? Yeah. And that was also constructed by international treaties. So my question is, right now, because you're in activist circles, there's a huge crisis at the border. Yeah. And one of the sort of undercovered elements is that there's this division between North American, Canadian, United States Native Americans, as well as Mexican Native Americans. Mm-hmm. And so they end up kind of doubly marginalized when they end up in our carcelary system, right? Mm-hmm. And I was wondering if you could speak a little bit about the lack of interpreters, the disparity in the justice system for Native Americans that go through the immigration system.
Yeah, thank you very much for asking me that. I'll just say up front, I know very little about immigration law. It's something that you always like, that's an area of study that I would like to accomplish to someday in my spare time. But yes, it's sort of like, for me, there is a reckoning, or sort of that's not the right word, a referential to the forced removals. There's passages and barriers and cages and movement back and forth that are happening. And we know that the history of those kinds of moments has never resulted in anything particularly positive in terms of outcome. And so I would say that if we put this current moment in its historical context, it is a continuation of moving and capturing and caging Native bodies. So that would be the conversation that I would love to have with you at some point over coffee in the future. Thank you for the question.
Thank you. Thank you very much. I think it's probably time we let you go, Sarah. Thank you so much for your time, for your wonderful talk, for educating all of us tonight on these very important and very difficult issues to think about. Your courage, your commitment, your activism, your scholarship, they're all admirable and inspirational. So thank you for all of that. And we hope to bring you back for real to campus once we get to the other side of this terrible plague, as you called it. So I would like to leave everyone with that thought, that hopeful thought.
Ratul, can I interrupt? And just, there was a question about whether the recording will be posted anywhere. Can we tell folks where they can find it?
Yes, I just saw that. Thank you. Thank you, Jesse. So I'm going to send the recording to the president's office and they process it and they put it on the YouTube channel, I'm told, with like the rest of the presidential events. I would like to also put the link on the WICSEX program page on our website. I'm not sure how long all of that's going to take. I will send it over to them and I'm happy to send out an announcement, or you can check in with me and say like a week and email me and I'll be happy to share. So it's not on me to publicly share it, make it public somewhere, but the college will, if that's helpful, right? And then Sarah, before we let you go, I want to make sure we have your correct address to send you your award. The address on the paperwork that we did.
Yes, I sent you right before I got on here this evening. I responded to the email. Yeah.
We want to get that to you as soon as possible. Thank you again, everyone. And just a very quick note, stay tuned for next week's events. Our WICSEX Colloquium speaker series is taking place next week, Wednesday and Thursday, and there'll be more information on Inside SMCM. And once again, Sarah, thank you for being here. We appreciate you so much.
Thank you so much. Have a wonderful rest of the evening, and I hope to come back to my birth state of Maryland at some point in the future. Thank you again.
Yes, we will make sure that happens. Thank you so much and have a great evening, everyone.
Bye.
Bye-bye.